Once again, a very happy new year to you all. It's my pleasure to welcome you to this webinar, courtesy of the East Africa Law Society Women Lawyers Committee. I know today it is Valentine's Day, so happy Valentine's Day to anyone who has not yet been wished. Happy Valentine's. It's my very great pleasure to welcome you to this forum. Our topic today is assisted reproductive technologies, the law and trends in the East African region. So assisted reproductive technologies can be defined as the different methods or technologies that can be employed to assist individuals to achieve conception or pregnancy. And these are the individuals who cannot do that spontaneously. So here in Africa, especially in sub-Saharan Africa, assisted reproductive technologies is still a taboo topic. This could be the reason why we have very low rates of ART. Let's mute so that we don't have any interruptions. Yes, thank you. So as I was saying, we have very, very low rates of assisted reproductive technologies. Maybe it is because here in the sub-Saharan region, it is still a taboo topic, and we have not really fully embraced the topic that reproduction or that sexual health can be assisted through other external factors. We still believe it needs to be spontaneous and it needs to be natural, but that is not always the case for everyone. There are some of us within the community who need some help. And this could be the reason why sub-Saharan Africa has the lowest rate of assisted reproductive technology utilization. And the rate is currently 71 cycles per population of 1 million per year. If this is compared to the global rate, the global average is 477 assisted ART cycles per million population, although statistics show that the need is about 1,500 cycles per million population per annum. Also, the other aspect that we are going to look at today is whether the legal regime in the various countries in East Africa have caught up with this fairly new phenomenon of ART, that is assisted reproductive technologies. Currently, only Rwanda has enacted laws relating to human reproductive health. Uganda and Kenya currently have pending bills. And there's also a pending bill at the East Africa Legislative Assembly, being the EAC Sexual Reproductive Health Bill of 2021. To help us really unpack this topic, we have very eminent speakers. Our panel is made up of very eminent speakers who are experts in the field of ART. They will inform us about the experiences and the difficulties and challenges that are currently being faced by members in the East African community. They will also inform us about the latest developments in the legal, medical, and ethical arena of ART. Before I introduce the speakers, some housekeeping rules. Feel free to post your comments, reactions, and observations on the chat section. And because today is Valentine's Day, you can also network and introduce yourself. Tell us where you're from, of course, on the chat section, because I hear Cupid is in the air, and who knows, you might just be shot by Cupid's arrow. And then we are going to have a plenary session after the speakers have all finished with their presentations. However, if you have a very burning question, or if you think that maybe you might lose your question, you can post it on the Q&A section. But we are going to have a plenary after our speakers have finished their presentations. So our first speaker is Mr. Chris Sengoga from Rwanda. He is the director of this. He is the director of the Center for Health and Rights at the Health Development Initiative in Rwanda. The Health Development Initiative is an NGO that uses a comprehensive strategy combining education, advocacy, and health system strengthening to improve the quality and accessibility of healthcare in Rwanda. Chris, take it away. We are waiting. Thank you.
Everyone, I hope you can hear me.
Yes, we can hear you loud and clear.
Wow, that's great, because I was struggling with now connecting to another computer. The one I had issues with the microphone, but now I think I'm clear and loud.
Yes, and we can also see you.
Oh, that's great. So thank you so much for this opportunity. Indeed, it's to me, I take it as a platform for sharing experience and also learning from different speakers, but also people who have just connected. They might have as well information that is very legit and complement what we shall be discussing. I like the introduction you've made, that at least it lays a ground for all of us as panelists to go around assisted reproductive technology. On the topic that I'm supposed to allude on, I've read through the UN guidelines on children born out of surrogacy. I've tried to look into the regional practice and experience. I've also prepared a case that we shall be sharing with the entire team. And I may say that today, it's really challenging to have the international surrogacy guidelines that are harmonized and universal. Because currently, when I was trying to do the reading in the previous days, it was very critical that you find that very few countries have just put a legal and a policy framework which just looks into the territorial jurisdiction that does not go beyond the domestic sovereignty. And when I was looking through the UN guidelines, I found that at least they have tried to lay a foundation on which shouldn't be done and what should be done. And in all, they have at least tried to highlight that there is a need to establish some preserving mechanisms of child identity, which has been difficult ever since the technology on assisted reproduction has come to the international arena. I've also found that it's still challenging in many countries, that it is, in some countries, even it is impossible to get the statistics of how many children are born out of surrogacy or this assisted reproductive technology, because it is normally taken as a bilateral agreement between especially the donor and the recipient, and sometimes it doesn't go to the public, and even through some public institutions who should regulate the application and the whole procedure. I believe that when the UN guidelines highlighted also the legal parentage in surrogacy to protect the rights of the child, and also emphasizing on the greater risk that these children sometimes are involved, they are involved when they are not protected, when the procedure is not protected, when the whole process is not protected, there is a risk for especially those who engage in commercial surrogacy arrangements, that children are trafficked and sometimes they are on sale, and also exploitation of the surrogate mothers. And I think that's why some countries that like UK, they don't even, they don't allow commercial surrogacy, because they think that people who will offer some money or material gains will be exploiting the surrogate mothers who sometimes they are in need. And this can also create a situation of stateless, where you find that children born out of the procedure are not really protected. So when I was also looking into the concluding observations and recommendations from Convention on the Rights of the Child, I found that the thematic group, the committee, they sat with the special rapporteur in charge of the rights of the child, and also the one in charge of the child in UNICEF. They came up with recommendations that at least all states should put in place a legal and policy framework that protects these children, especially when it comes to civil registration of these children, that most of them, their identities are lost somewhere, either to surrogate mothers or the donors. So it becomes very complicated. And when a child is growing up, sometimes she doesn't even know her origin, which makes it very impossible and difficult for these children to have the spiritual and physical development that should be part of their best interest. Timely and disaggregated data on children born through surrogacy could be corrected by states. And national legislation, as I alluded on earlier, and also the intermediaries in surrogacy should be prohibited. I think, you know, when people are doing business, there are those they call brokers, there are those that come into the process who can abuse the whole procedure and the process. Yeah, that's what I managed to look at when it comes to UN guidelines. And coming back to the regional experience, I spoke to a number of persons working in different countries across the East Africa. And I think our colleague from Kenya will also share your experience. I found that in Tanzania, they have the IVF clinics, in Rwanda as well. So far we have 2. In Uganda, they do. But none of the states really have a clear regulatory and policy framework, which makes it difficult for the protection and safeguarding of these children, and even the mothers, especially not the donor, but the ones who act as surrogate mothers. Which brings me now to the bill, however much it is still a draft. I think in its Article 21, that at least for it, it has tried to highlight what commercial surrogacy means, assisted reproductive technology, what it entails, which is largely lacking in other jurisdictions across East Africa. However much it is still a bill, to me, I believe that whenever it is passed, at least it will be a guiding document that at least which unifies the East African countries, bring the harmony, bring a legislation that at least countries which don't have their distinctive legal framework can refer to the procedure, can refer to the guidelines of the East African Reproductive Health Bill once it is passed. Coming to Rwanda, because I tried to avoid going into the technical part, because I know my colleague we'll allude on. I found that there are two, we can always look into assisted reproductive technology in two lenses. One consideration should be the ethical consideration, ethical guidelines when it comes to the whole process and whole procedure. And this is normally done at the health facility, at IVF clinical health facility. And another consideration is family, because it now involves the protection of the child and also protection of the identity of the surrogate mother, which now this goes beyond the health facility. This is where now we need a clear regulatory framework, a clear policy and protection from the law perspective to protect now the family, both the child and the surrogate mother, and the whole procedure and the process. And as you talked about earlier, that Rwanda at least has tried to put forward or to enact or establish a human reproductive health law. To your surprise, it doesn't capture any procedure when it comes to assisted reproductive technology. Actually, when you look at it, it only talks about a treatment of infertility in provision in its Article 3 of the law, which makes it ambiguous. And this is why I'll be sharing a case where you will find that when a certain couple wanted to have the procedure, it was very difficult for gynecologists or for the facility now to respond to their request or their need, because there was no legal framework. There was no clear regulatory framework that could guide them. And their fear was, what happens to the protection and safeguarding of the child and then the surrogate mother, if at all we accept and do the procedure? In the law on human reproductive health, in its Article 3, it only talks about the components of sexual reproductive health, which includes family planning, prevention and treatment of HIV, prevention and treatment of sexually transmitted infections. And in its line subsection 6, it's only where it talks about prevention and the treatment of infertility, which makes it very hard to interpret this provision when it is read together with a request of a woman who needs to have a child through assisted reproductive technology. And surprisingly, in its Article 6, it's where now it talks about the right to information and also to medical treatment, which is why when I'll be explaining the case, I will try to use these two provisions. As I highlighted earlier, that assisted reproductive technology has to be looked into using two lenses. One is the health perspective, and the second one now is the family, which now takes me to the case of this couple. So the case actually came up in 20. At first, the couple went to. So far we have only two IVF centers. One is Medhill, another one is Rwanda Military Hospital. Then, for the first time, they sought for advice from the Medhill IVF center or clinic, and they advised them that When it comes to surrogacy, it is complicated because they don't have a guiding document, not the ethical considerations, but a guiding document on how it should be, what should happen after the procedure and the process. And then they referred them to military hospital. Upon reaching to the military hospital, that was 2019, they met a famous gynecologist who advised them that they should go to the Ministry of Health or seek some further advice from any other authority or institution. And when they went to the Ministry of Health, they told them that they can only look into what is provided into the family law because it has that provision. And when they got stuck, now they had to go and seek advice from a lawyer. And you know what lawyers do? It's going to court. Because if all options are now failing, a lawyer advised them to go to court. So they filed a case to primary court. I believe in the common law system, you normally say the court of magistrate. That's the first court of instance. So when they went to primary court, they presented their case. And it was surprising that the female judge did not understand it because it was the first time when she heard about people who are requesting for assisted reproductive technology and to be assisted in terms of technology to have a child. And when you read our provision in the family law, Article 254, which reads that production occurs naturally between a man and a woman, or it is medically assisted. And the second paragraph reads that medically assisted procreation must be by mutual consent of the concerned. And the judge interpreted the second paragraph that the mutual consent of the concerned is only between a wife and husband, not the third party. And you know, normally surrogacy requires a third party because the woman in the quotation could not bear a child. So they lost the case in the primary court. When we heard about the case, we invited the couple, we started discussions and we advised them that they can appeal. And now they filed an appeal in intermediate court. That's the higher court to the primary one. So when it was heard in September 2020. When we reached into the intermediate court, HDI, we applied as a friend of the court or amicus. University of Rwanda. University of Rwanda was also amicus. And they also, the court also requested an organization that promotes and protects the rights of women and children. It's called Haguruka. So you can imagine the three friends of court in the same case to explain the matter at hand. So the couple was present, and I liked the judge where he requested journalists that if they are trying to cover the story, they should try to protect the identity of the couple. That's the wife and husband, which they did. But of course, later when the case came out, the names had to go out, which makes it also vague because you can't protect the names in the pleadings and then the names comes out later. So the judge asked the couple what they really wanted. They explained with their lawyer. And it was my first time to see judges, the panel of judges who are very humble to learn. Because it was first of its kind in our jurisdiction. They had never heard about it. So that's why they invited all the parties to come and explain to the courts how surrogacy is done, what it means, what are the effects, what would come out, all such was the discussion and pleadings in the court. To the surprise, the organization that was protecting the interest of the child and women, they advanced that a child, if the procedure and the process is done and done successfully, there should be a protection of the child, and the child should be placed to the biological mother for at least 6 months or 1 year for breastfeeding, so that after she's handed over to the surrogate mother. And then we had read about the experiences in other countries where such agreement was approved. And then later, the biological mother refused to give out the baby. So we advised the court that it shouldn't be that way. The court should order that upon birth, the child should be registered to the couple that requested, but also should at any time upon request get to know the information about the procedure and the process, how he or she was born, which we believe the court took into consideration. But when the judgment came out, we found that the court ordered otherwise, that upon birth, the child should stay with the biological mother for at least 6 months to be breastfed, and then she can be handed over later. So I would conclude saying that in Rwanda, we are not so that advanced. However much we have a human reproductive health law, it does not really capture issues to do with assisted reproductive technology. It's now that we have engaged the line ministries, including on forefront the Ministry of Health, and now they have made a draft law that regulates health in general, where they have at least put the procedure, and still it is still a bill or a draft that we are yet to engage and trigger the discussions to see that at least women and all other parties that want to have use assisted reproductive technology have their full rights as provided in our constitution, especially provision 21, which talks of a right to good health, and also provision 17 and 18 that talks about the protection, the right to have a family and the protection of the family. So I don't know whether I have not consumed more minutes than I was entitled to.
Chris, you are right on time. And okay. Thank you very much for the elaboration, especially for highlighting the problems that lack of a legal framework pose to our people who want to access assisted reproductive technology. And even the fact that most of us don't know exactly what ART is, for example, what surrogacy is. And I'm glad that the judges in Rwanda took that case as an opportunity to learn. So now let us shift gears a bit to hear a little bit about the medical and the ethical aspects of ART. And to take us through that session will be Ruby Ayeta Lumbasio. Ruby is a lawyer stroke doctor, or she has both legal and medical and medical know-how because she holds an LLB and she also holds a Master of Science in Medicine. She's an advocate, a bioethicist. Members note she's a bioethicist and a scholar She's a member of the LSK, of the European Society of Human Reproduction and Embryology. She's also a member of the American Society for Reproductive Medicine and an associate member of the Kenya Medical Association, KMA, and a member of the Bioethics Society of Kenya. Currently, she's the Legal and Ethics Officer at the Nairobi IVF Center and is the founder of the Fertility Law Center. Her areas of interest are assisted reproductive technology, that is ART, stem cell, genomic sequencing, organ donation, bioethics, and medical law. Members, let me assure you that that is a condensed version of her bio. We are eager to hear from you, Ruby. Karibu sana.
Thank you, Angie. Asante kwa kunichocha. For East Africans, the ones who don't understand what I'm saying is I'm just saying thank you for all that. So let's just, I have so much to present because apparently I've been put to do medical and ethical trends. So I will have to, I will have to, your screen sharing. Okay. Just a minute. Okay. Can you see? Is my screen being shared at the moment?
Yes, I can see your screen, but it's not full screen.
Or do you need me to put it full screen?
Yes, it's visible. At least we can see.
Okay.
You can proceed in the interest of time.
So, yeah, okay. So, of course, as Africans, we always start with the Bible quotation, behold, children are a heritage from the Lord. The fruit of the womb, a reward, like arrows in the hand of a warrior, are the children of one's youth. Blessed is the man who fills his quiver with them. That is the wish of so many people. So what is our objective on this, on my presentation today? We are going to jump to 2 types of ART, and then we identify the ethical issues in assisted reproductive technology in East Africa, and then the sources of the ethical guidelines of ART in East Africa, and of course, chart a way forward. So, right to reproductive health. I have questions for you. Do human beings have a right to reproduce? Do we really have a right to procreate? Is it a right? Is it a God-given right? Or are we just keeping it in ourselves and deciding that we want to reproduce or procreate? Most importantly, what's the difference between reproduction and procreation? And what are the corresponding duties if we indeed have the right to do the said reproducing or procreating? And then, is infertility a health or a social issue? And once we have decided if it's a health or a social issue, should we legislate on matters to do with reproduction and procreation as we consider these bedroom matters? That is food for thought. We do not necessarily have to think about it now. So, infertility. World Health Organization describes infertility, or rather clinical infertility, as inability to conceive after more than 1 year of regular unprotected sex, or less depending on age. So if you are, say, 35 years and below and you've been having unprotected sex and you haven't been able to conceive for 1 year, you might be having a type of infertility. But if you're older than 35, it reduces to about 6 months. There are 2 types of infertility. There's primary infertility, where you have never been able to achieve a pregnancy or procreate or reproduce. And the secondary infertility, where you once were able to reproduce and now you cannot be able to reproduce. Someone mentioned that there is a tertiary infertility, which I do not understand that. So what are the reasons for male infertility? Mostly it's about the sperm. So sperm production and sperm count disorders. I may be able to share some of these notes, so we will just go through them quickly. There's azoospermia, where there are no sperm cells produced at all. And then there's oligospermia, where very few cells are produced. And then, of course, the erectile or ejaculatory deficiency. Some of you like popping the blue pill. This is where this comes in. So you may be unable to conceive as a male person to make a woman conceive because of erectile dysfunction. And of course, structural abnormalities. Sometimes the sperm is shaped in a way that it cannot penetrate an egg. So it becomes a little bit hard for either it to swim or to bind with an egg. And then age, of course. Men always think that they can sire children at any age. Yes, you may be able to sire that, but it comes with a lot of consequences. So many diseases can be had if you're going to sire at an old age. What about the women? Reasons for female infertility includes ability of the ovaries to produce ova. Perhaps you cannot be able to produce, ova is eggs. You cannot be able to produce eggs, maybe because of age, or you have other ovulation disorders like PCOS. You may have blockage of tubes. You may be of an advanced maternal age. The problem with eggs is a woman is born with all the eggs that she'll ever own in her entire life. Every year when she starts her menstrual cycle, every month she sheds a lot of eggs. By the time you have shed eggs for like 10, 20 years, you have shed a lot of eggs, and there's no way you can add more eggs to your being. Unlike the men who reproduced the sperm, it keeps multiplying all the time. So the number of eggs you're born with is what you have, and it keeps reducing every month when you have your monthly periods, not by one, by a lot. And then, of course, quality of uterine lining. This is especially for women who will require surrogacy. Now that we've seen what infertility is, what are the types of assisted reproductive technologies? Actually, nowadays, it's called medically assisted reproduction. That is why I have put ART/MAR. I just base it as work up the machine. Assisted reproductive technology was defined by Angie. These are the types of assisted reproductive technologies. There's the IUI. We'll look at each individually. There's IVF. There's ICSI. There's GIFT. There's third-party reproduction, which includes gamete, that is the sperm and the oocyte donation, gestational surrogacy, and three-party reproduction. IUI. The most easiest way to explain what IUI is artificial insemination. Most of us did agriculture in high school or primary school. So the way artificial insemination happens, the way you take sperm and you place it inside a woman's uterus to facilitate fertilization. That is what IUI is. In human beings, we call it IUI. In animals, we call it AI. The goal is to increase the number of sperm that can reach the fallopian tubes and, of course, subsequently increase the chance of fertilization. And this is mostly used where there is low sperm count or reduced sperm mobility. This cannot be used where there is no sperm at all, because what are you shooting up there anyway? So basically, this is the IUI process. We start with one. We induce the woman either through use of medication or injections. There's some hormonal drugs that you're injected with. And then we prepare the sperm. Sperm usually is collected through masturbation. And then once it has been prepared, by preparing sperm, there's washing and stuff like that. And then it is transferred to the uterus through the vaginal cavity. And then we hope a pregnancy is achieved. Usually you transfer it when the woman is ovulating. IVF, the most common, the most basic assisted reproductive technology. Actually, apart from IUI, every other form of assisted reproductive technology kind of stems from IVF. IVF is in vitro fertilization. In vitro simply means outside the uterus. So in vitro fertilization, of course, it is the process of fertilization by extracting eggs from a woman, retrieving sperm from the man, of course, and then manually combining them in a laboratory dish. It used to be a test tube. That is why IVF babies are also called test tube babies. And then the resulting embryo is transferred to the uterus. So as you can see, there's a petri dish there. They collect eggs, collect sperm, manually put them together and hope that a fertilization occurs. So the IVF process involves ovary stimulation. Usually a woman produces, by the time she's getting her period, she has produced only one egg, but because we want to stimulate as many eggs, we want to fertilize as many eggs as possible to retrieve them and all that, you get stimulated, you're injected for a period of 5 to 10 days, depending on your hormonal levels. And then oocyte retrieval, oocyte is eggs, eggs are retrieved. And then sperm, of course, is retrieved on the day the eggs are retrieved, or perhaps you retrieve the sperm much earlier and had them stored. And then fertilization occurs outside the uterus, and then the resulting embryo is transferred. So this is the process of egg retrieval. As you can see, it's vaginal. Once you have been given injections for like 10 to 14 days, between 5 to 14 days, depending on your hormonal levels, and the injections are just to enable you produce more than one egg so that we may harvest as many eggs as possible to enhance the chances of fertilizing as many eggs as possible so that some embryos can be created through that. So a needle-guided, an ultrasound-guided needle is through the vaginal walls, as you can see, goes to the follicles directly, and then it has pressure pump, and then it retrieves the egg into this tube. And then this tube, the embryologist now will take one egg by one egg and do the fertilization. Sometimes men, or rather I should just say most times, men, even in their embryonic, even in their sperm stage, cannot ask for directions. So if you just combine, because this is the basic way of fertilization, you combine the eggs, you just put them in a petri dish, an egg and sperm, and let the egg find the sperm, and let the sperm find the egg and fertilize, as it usually happens in a womb, but now outside the womb. But sometimes the sperm cannot find the egg, cannot fertilize, maybe because it has a problem with the shape or the swimming capabilities and stuff like that. And men just don't ask for direction, even when they're in a sperm kind of wherever. So that is when we inject a single healthy sperm injected directly into a mature sperm, into a mature egg. ICSI is often used where semen quality or number is a problem, or if fertilization attempts during prior in vitro fertilization have failed. So once that has happened, an embryo undergoes such development. It forms all this, and then it is transferred. You can either transfer the embryo that has been created on day 3 or day 5. Embryo transfer is vaginal. It's just put through the vagina with a needle-guided ultrasound needle, and then it's put in the uterus. So that is IVF. This is the process, the whole process from 1, egg production stimulated by hormone therapy, and then the eggs are retrieved from the ovary directly. Sperm sample is provided mostly through masturbation, but sometimes men cannot produce sperm, so you have to do testicular aspiration, meaning surgically retrieving the sperm. And then the egg and sperm are combined to allow fertilization. And if that cannot happen, then ICSI happens, where you directly inject the sperm into the egg, and then you let the embryo culture, it's called culture, grow for like 3 to 4 days to 5 days, and then you introduce that into the uterus and hope a pregnancy is achieved. So we have finished with IVF. IVF, ICSI, everything else falls under IVF. Part of the IVF process, now that we have IVF and all that, is the pre-implantation genetic diagnosis, screening, and testing. I have put there designer baby anyone, because this is a technique used to identify genetic defects in embryos created through in vitro fertilization before pregnancy. That is why it's called pre-implantation genetic screening or diagnosis or testing. And then it's used for detection of genetic or chromosomal disorders before an embryo is transferred. So once maybe on day 4 of the embryo culturing, embryo is biopsied, that is, a piece of it is removed, and then it's taken through the testing process to show if it has all the chromosomes that it's supposed to do. And if you have maybe a genetic disease, you can test here. If the parents maybe have sickle cell and albinism or other genetic disease, it's pre-implantation genetic screening tells you which embryo has the genetic disease, which embryo is a carrier, and which embryo is, I do not want to use the word normal, does not have any of that disease. Then you can decide to transfer either of the embryos, whichever, either the one that has is a carrier or the one that does not have diseases. Unfortunately, because of that, it has led to some ethical and legal issues, because PGT, the pre-implantation genetic screening, is supposed just to help you to produce a healthy child. But people go out of their way. Once PGS has been done, it actually tells you the sex of the embryo. For instance, if you do screening, say for sickle cell, it will tell you embryo number 1 is a carrier and is a male embryo, or embryo number 2 has no disease whatsoever and is a female. And so at the end result, it actually tells you the sex of the whatever, because most diseases, genetic diseases, are sex linked. So it comes to issues of creating designer babies. What are we going to do with the unwanted embryos, the ones that are carriers, the ones that you do not want, the girls, mostly the girls that you do not want to implant into the embryos? So isn't that a form of discrimination? Can we call that a form of infanticide? The way in India, for instance, people sleep on their baby girls so that they can die and then they can birth other children. So these are the legal challenges that happen to PGS. There's the status of the embryo, because now you're discriminating against it. You have the chance to create a designer baby. You have a chance to select sex selection, and then there's destruction of unwanted embryos. Question. Sarah is 30 years old. Previous genetic testing shows that she's a carrier of cystic fibrosis. Her partner is a carrier as well. Despite the fact that she's not infertile, she seeks IVF treatment at an assisted reproductive technology clinic at a public hospital in order that any resulting embryos can be screened using pre-implantation genetic diagnosis, and only embryos without the CF, the cystic fibrosis gene, will be implanted. What's your opinion? You can just keep it and then we'll discuss maybe later. Another mode of IVF, as I said, all this falls under IVF. How we proceed with that is sometimes you find that people do not have gametes. As I said, women, when they grow older, or because they have some PCOS or other diseases, their eggs may not be quality. They may not have a quality or quantity of eggs, and they may need an egg donor. Same to men, sometimes because of issues here and there, the man may need a sperm donor. So let's look at the gamete and embryo donation. Gamete is a collective word to denote sperm and eggs. There's sperm donation, there's egg donation. Women and men donate. Sperm donation is very easy. It just happens through masturbation. We cannot do testicular aspiration for sperm donation. Where a man has to be healthy. A man has to be between 18 years to 35 years, must be of average weight, not overweight, not underweight, must not have genetic disease. And if perhaps they suspect they have a genetic disease, then we will have to do pre-implantation genetic screening. But now it is not pre-implantation. We will just be doing genetic screening, which is called genomic sequencing, one of my other favorite areas of interest. And then they have to do the donation through masturbation. And of course, being third-party reproduction, consent has to be obtained. What about the ladies, the egg donation? Usually, fertility centers prefer ladies between 18 to 25 years, because that is when your follicles, that's when your eggs process has really matured well. And of course, you're of an age that can give consent. Non-smokers are preferred to smokers. Genetic disease test is done. And at that time, we do not want you to be on birth control because it prevents the release of eggs. A stimulation process, as I've explained, has to be taken, has to happen, and then retrieval. And of course, consent is needed. Do these people get paid? Because it denotes it's a gamete donation process, it is not a payment per se. It is some compensation, maybe transport and all that. And in Kenya, mostly it ranges between 40,000 to 100,000. If that is fair or not, I will leave it up to you. Question. Desiree, a 35-year-old lady, is now 35. In her youth, when she was 23 years old, she donated her oocytes, her eggs. And her eggs were used successfully, and a couple were blessed with twins. Now, years later, say she was 23 now, she's 35 now, that's 12 years later, Desiree is married and has been unable to have her own children. She remembers the eggs she donated and approaches the fertility center where this was done, hoping that she'll trace the children born out of her donation in the hope that she can claim them as biologically hers. Do you think these are her biological children, having donated the eggs in her youth? And with our system, lack of laws and all that, would you be able to trace who the children went to? Because we do not do data compilation and stuff like that, and other etc things. This is food for thought as well. Actually, these cases that I'm talking about are live cases, cases that happen, like literally happen. Another form of assisted reproductive technology, gestational surrogacy, titled it, My Baby, Your Womb. Not flesh of my flesh, no bone of my bone, but still miraculously my own. Never forget for a single minute, you did not grow under my heart, but in it. What is surrogacy? Surrogacy is an arrangement usually supported by a legal agreement where a woman who is the surrogate mother, a host, agrees to bear a child for another person who will become the child's parent after birth. It's basically a practice where one woman just carries a baby for another with the intention that the child or that has been born shall be handed over after birth. This is the most common form of third-party treatment option for infertility. As I've mentioned, there's also egg donation and sperm donation. Anything that happens with more than 2 people is called third-party reproduction. And third-party reproduction actually needs more consent than the normal reproduction, because now you're using a third person to help you complete your family. Reasons for surrogacy. There are medical reasons why a woman may need another woman to carry for her a pregnancy. Some of them are absence of uterus. Some people are born without a womb, or they happen to acquire diseases like fibroids and other things and must have the womb removed. And then there's the significant uterine disease. There's uterine malfunction. There's some uterines that are heart-shaped, abnormally shaped, or there's scar tissue, so the woman cannot be able to carry a pregnancy. Repeated IVF failure. There's repeated implantation failure, and there's repeated miscarriage. Recurrent pregnancy loss. That may mean that maybe someone's womb is not sufficient enough to either carry a pregnancy or sustain the pregnancy to term. Absolute medical contraindication to pregnancy. Maybe they have a heart disease, cancer, the person has been a multiple organ donor or a recipient, or has hypertension, and that prevents them from carrying a pregnancy. And of course, to the gays, biological inability to conceive or bear a child. Well, they do not have a womb. And age. A 50-year-old lady, yes, can carry a pregnancy, but is it safe for her? Is she gestationally safe to carry a pregnancy? So what I always say is surrogacy is a balance of need versus convenience. It should not just be convenient to you to put somebody through the process of pregnancy just for your own sake. There are 2 types of surrogacy. There's traditional surrogacy, there's gestational surrogacy. Traditional surrogacy uses the IUI. You remember we talked about IUI process? You put the sperm into the woman's womb. This means that the surrogate is also the biological mother of the child, and therefore the legal mother, she's the birth mother, the biological mother, the host mother, the every mother. I'm not sure if there's any country in the world that recognizes such kind of surrogacy, because it's really hard to legislate upon it. How do you give out a child that I have birthed with my own eggs and my own womb to somebody else? So usually it's guided by a gentleman's agreement, and most fertility centers, at least the ethical ones, would not touch this with whatever foot long. And then there's the gestational surrogacy. This is where the child is not biologically related to the surrogate mother. The surrogate is also called a gestational carrier. Instead, an embryo that has been created through that IVF process that I explained is now implanted into a surrogate instead of the intended parent. Same process, same procedure. The only difference is when it gets to the embryo transfer, it is not implanted in the intended parents by a womb, but it is transplanted into a third party. Usually the surrogate has gone through medication to prepare her womb to mimic a normal uterine kind of preparation that usually happens when someone is going through the normal periods. And then once the womb has, the uterine is of a certain length, of a certain width, the embryo is transplanted into that. The first surrogacy, gestational surrogacy, was achieved in April 1986. The first gestational surrogacy in Kenya was in 2007. So as you can see, this is not such a new thing. The first IVF baby in Kenya was in 2005, followed by Uganda. Uganda, our neighbors here, were the second ones in East Africa to get an IVF baby, I think a year later. And then, of course, we actually had a surrogate birth in 2007. This is the process. There are three parties. There's the man, there's the woman, and the bearer of the womb. Some people call it renting a womb, but I think that's just not nice. So this is the surrogacy process in Kenya. We do not have a definite surrogacy process in Kenya, but from practice, as I've said, we've been doing these things from 2007, from practice and from looking at best practices abroad and being members of various international bodies, we have streamlined it to this. First, intended parents are medically cleared for surrogacy because you do not want just to put somebody through a pregnancy and birth process for the sake of not growing fat or something like that. And then there's a screening and selection process for a surrogate, which includes pre-surrogacy counseling for the intended parents and for the surrogate herself. And then, of course, legal consult and agreements. It is important to have an agreement in place before you start surrogacy because this is third-party reproduction. Unfortunately, assisted reproductive technology is not even primary care. It's not even secondary care. It has been lumped with things like plastic surgery, UCO on third, things that are not important. So things that apparently are not so important, you need to get permission every step of the way. Have the people signed consent forms? Have they, have they gone through psychological analysis, counseling and all that? Then and only then is when you go to the clinical process. And then hopefully a pregnancy is achieved. A birth pregnancy will just be like a normal pregnancy, a birth process, and then child registration process. Why I've put adoption is because a lot of countries that do not have laws have been going through that process of adoption. We were even some case laws, as maybe my colleague Enrica might point out. We had case laws here in Kenya where adoption had to be done, but now there's another totally different process that I'm hoping Enrica will point out during her session. Key requirements, of course, medical clearance for surrogacy. That's important. We prefer that there's a genetic link to intended parent. The ideal situation is where we use the intended parent's eggs, we use the intended parent's sperm, we combine and put it in a surrogate. The next ideal situation is where one party has a donation, either an egg donor or sperm donor, and then the intended parent has the other gamete, combine, put it where. But the one that is egg donor, sperm donor, surrogate, whose baby is this? Why are you creating a baby from nowhere that has no genetic links, has no connection to anybody? Why not just go and do adoption? Because it's the same kind of thing. And then, of course, a written surrogacy agreement in Kenya. It should be noted that no surrogacy agreement in the whole world is enforceable. They're just usually persuasive to show, and they used to show the intention behind the whole process. Surrogate requirements, they must be 25 years and above. At least must have had at least one live birth. You don't want to put a woman through the surrogacy process and then at the end of the day, she loses her womb or she dies in the process or something like that, and then she becomes a patient. And then medical clearance, criminal clearance, and psychological analysis, important. We don't have laws on surrogacy yet, and ART, but what do we use? We use things like constitution. Our clinics use things like constitution that provide right to founding families, Children's Act. All the East Africa countries have a Children's Act or a version of it, the African Charter on the National Rights of Children, and the UNCRC, they provide for rights of a child, and they also give you some parental custody, processes on how to go about transferring rights from a person who gave birth to a person who did not give birth. Penal code. In places like Uganda, you cannot do IVF for gays because, of course, they have gayism is illegal. In Kenya, we have a penal code that says same-sex relations are not are frowned upon. So some clinics, and myself included, do not do surrogacy for gay couples because once they go through the child registration process, they'll just find issues there. And what's the point of putting a child through that whole process? I'm sure this Enrica will speak about this. So the countries, now that we've seen the various assisted reproductive technologies, which countries in East Africa are doing it? Kenya doing IVF, so is Rwanda, Tanzania. I don't know about South Sudan, and Uganda is also doing IVF. Gestational surrogacy, all the 4 countries that I mentioned are doing surrogacy. They do not have the laws, yes, but they're doing it. PGS is mostly done in Kenya and Uganda. You know, the thing about East Africa is we have predominantly the same, except Rwanda. Rwanda is the one that is a little bit different, maybe because of the language barrier and stuff like that. But in these other 4 countries, we have predominantly the same fertility experts, and then they have opened branches in the other countries. So you'll find in Kenya, you have, say, Mediheal, and then it has a branch in Tanzania, and then you'll find Dr. Tamale from Uganda with a branch in Dar es Salaam. So it is the same circle, but so they do practically the same things in those countries that they're opening branches. And then cryopreservation is the storage of extra embryos. You may, when you have created, as I said, when you're retrieving the eggs, retrieve more than one. So you may create embryos and then you find at the end of the day, you have 8 embryos. You cannot transfer all the embryos at the same time. So you may transfer 2 perhaps, and then you have 6, which you can store, and they can be used for frozen embryo transfer. Frozen embryo transfer and fresh embryo transfer relatively have the same success rates. The difference, the margin difference is quite so low, and frozen embryo transfer, embryos can be frozen for as long as possible, even 10, 20 years. But because of ethical issues, we prefer freezing for not more than 10 years. Because once the child is 20 years, how are you going to give birth to her brother or sister or whatever? It just becomes a whole lot of ethical and social kind of quirky things. So gamete donation also happens in all the 4 countries. Assisted reproductive technology law is non-existent in all. Rwanda, as the gentleman before me said, has a little bit on it, but does not go into depth. So enough with the medicals. Let's do the ethical in 2 minutes. What are the ethical issues in assisted reproductive technology? We'll start at the core level when you are starting out the treatment. Informed consent. As I said, this is not primary care. So you must have consent every step of the way. The consent to be informed has to be voluntary, be it an egg donor process, be it an IVF process. I've seen husbands literally forcing their wives to go through IVF process and threatening them that they will marry a second wife or third or fourth or whichever. The person entering into this has to have capacity to enter into an informed consent. And capacity, you may have legal capacity, but not have medical capacity. A person who has gone through infertility for quite a long time and is kind of a little bit depressed and all that, needs psychological counseling first and mental health treatment first before they can even have the capacity to start treatment, because perhaps they're going into it just for the sake, because of the depression that they've been going through. And then they must understand the risk and the benefit, especially for third-party reproduction. You must tell the surrogate that she may even die during the birth process, because we've had people die during birth process, even carrying their own pregnancies, that they may lose their womb. Like the egg donor that I spoke of, who now cannot give birth, needs to know that with age, the hormones do not affect the production of eggs, but with age, you may not have enough eggs to sustain you into 35, 40 years. Some people have eggs to sustain them into 50 years. Some by 25, 26, they've depleted all the eggs reserve, you see? So this is something that the egg donor needs to know from the word go, so that she makes an informed choice if she's going to donate or not. Confidentiality and privacy. This is matters of the bedroom, so to speak. So the doctors and the fertility centers need to have this confidentiality and privacy, just like all other medical care. Another ethical issue is the eligibility, especially in accessibility. Like in Kenya, for instance, the constitution says everyone has a right to found a family, and then goes ahead and explains what kind of family it envisions: a man, a woman, and children. You see, it has already indirectly locked out the gays, the lesbians, the single women, the single men, and other things. Penal code in Kenya and Uganda is punitive for parties of the same sex. Apparently, they're doing things that are not natural. I'm not sure what that means. There's accessibility, distributive justice. This means IVF is quite expensive. IUI is usually the cheapest, the one that I said, artificial insemination. That costs between 50,000 to 80,000. But when you come into the nitty-gritty, the golden IVF, the one that I said is the gold standard for assisted reproductive technology treatment, it ranges, the minimum you get is around 450,000. That is Kenya shillings. That's around $4,500. That is not small monies. That's a lot of money. And every step of the way, it goes increasing. So you find that you do not have enough money. And then disclosure, of course, of risks, especially for third party. You must tell them that if you implant 2 embryos, you have the risk of getting multiple pregnancy. If a person is elderly with multiple pregnancy, it becomes a medical risk. And then at the treatment level, the creation of the embryos, you cannot mix egg donor. If I do not have enough eggs and then I also need an egg donor, you can't start mixing gametes as if you're in some play wherever that you're taking esters and rubies and seeing which one then will succeed and doing picky ponky. There must be some ethical guidelines about it. And then the status of embryo depends from country to country. When does life begin? The constitution says life begins in Kenya at conception. When is conception? Due assisted reproductive technology. And then number of embryos transferred. Most first world countries have restricted this to only 1 so that multiple pregnancy is not experienced. However, Africa, because of lack of restriction and laws, may transfer even sometimes up to 3. You find somebody carrying triplets and then end up giving birth prematurely and even losing all the 3 because they could not be able to sustain the pregnancy. So that is something that also is an ethical issue. And then third-party reproduction, as I've spoken about it, donor anonymity. We do not want to disclose who these donors are, but later in life, you find that you may need to have something to show who this was. Perhaps when they need some extra supervision, maybe the children that a certain donor X helped produce have a certain kind of disease, and you need to track all that and stuff like that. Also about donor anonymity, you find Patricia comes to say Nairobi IVF Center, donates, goes to Medihill, donates like twice, goes to Aga Khan, donates like 3 times, goes to and then you find, and these are the people who seek such services. Usually you'll find they're from the same circle, their children go to the same schools when they grow up and all that. So you find this Patricia has donated to 7, 8 friends or people of the same circle, and they start finding themselves in the same Javas, hanging out, having sex, and you're literally having sex with your half sister or brother. So there has to be a restriction to that. And then in gamete donation, commercialization, the anonymity that I've spoken about, those are some of the ethical issues. In surrogacy, the autonomy, some of these surrogates are so desperate that they just want to enter into whatever form of agreement without necessarily giving informed consent. And because they're using agents, they are vulnerable to exploitation. There's the element of commercialization. You find some surrogates insisting that if you do not add me extra money for...
We need to wind up.
Okay.
Wind up so that we have time for the next speaker.
Okay, just give me 3 minutes. So these are the ethical issues, and then pre-implantation I have spoken, and then final level is the storage. How long should we store the posthumous treatment? If someone dies and their embryos are still available, should we treat? And then the disposition of embryos. How do you dispose of these embryos? So the factors that usually affect ethical issues: culture, religion, level of exposure and training, professional ethics, and existing laws. These are the sources of ethical guidelines. And in closing, points to consider: whatever you do, best interest of the child has to be of paramount consideration, welfare of the child, right to knowledge of origin, and what is the way forward, legislation and reciprocity, policies and regulations, advocacy, networking, and collaboration. Happy Valentine's Day, people. That's the end. Thank you.
Thank you very much, Ruby, for that very, very enlightening presentation. Apologies for rushing you, but we know this is a very loaded topic, so we have to give time to the other speaker. Members, you have seen there's a myriad of ethical issues and things to consider, you know, hard questions. We have seen there's no clear line. Is it, you think about some of the scenarios that Ruby has posed to us, you wonder, is it right, is it wrong? If you were in the same position, or if you know a loved one who would have been in that position, how would you have reacted? Anyway, as she has said, that is food for thought. So that was the medical and ethical aspect. So we want to now hear how the legal systems in East and Central Africa and beyond, how they have managed to go around this issue. Do we have laws? Have we legislated around or about ART? So to take us through this process, the legal aspect of ART, we have Ms. Enrica Dulo. Ms. Enrica Dulo is an advocate of the High Court of Kenya with over 18 years post-qualification experience, stretching in the civil society, academia, and she's currently in private practice. She holds a Bachelor of Laws degree from Dr. B.A.M. University in India, a Master of Laws degree in International Human Rights Law from the University of Essex. She holds postgraduate certificates in International Development Studies from the University of Oslo in Norway, in International Cooperation and Development of Human Rights, Concepts and Issues from the United Nations University in Tokyo, Japan. She runs her own law firm based here in Nairobi under the name and style of Dulo EA. And she has built her specialty in family law practice and has cut her niche in non-traditional family law practice in the area of gestational surrogacy. So Ms. Dulo, again, members, that is a highly edited version of her bio in the interest of time. So we are ready to hear from you on the legal aspect of ART. Karibu sana.
Thank you, Angie. Good afternoon, everyone from all over East Africa. My two previous colleagues have shared elaborately with you what's happening in the regional field, and I thank Ruby for giving that elaborate background on the medical bit and some of the clinical issues that are looked at when intended parents, IPs, are considering ART. Now, I'm gonna do a slide share. My slide share is in Word. And in my slide share, because the first speaker has confirmed to us that even though we have a draft bill under the East African community, no country yet has in Africa or in East Africa has any legislation on ART or on surrogacy. So what I've done in practice, and even when I train advocates in Kenya, because Kenya has two bills on assisted reproduction, I try to look at the legislative practices in other jurisdictions that have legislated on ART and surrogacy, so that if we are called upon as practitioners, then we can use some of these best practices to inform or to influence our practice. Secondly, I've extensively also looked at practices in other regions because Kenya is a regional hub, no lie about it. And not all our clients are locals. I've represented clients from Japan. I've represented clients from Japan, from Australia. I've represented clients from the US, from the UK, who, for one reason or another, decide to come and have their child in Kenya. And often when they want to live with the child, that's where my services come in as an advocate. Whatever it is that I do here as an advocate, the court process has to mirror, especially if they're from UK, it has to mirror what happens in the UK, so that when they go to the embassy, the British Border Agency, UKBA, does not turn them away, as previously happened in one of the cases where, if there's time, I'm going to share about that case. So I'm going to do a slide share of the comparative analysis. Okay, there we go. Is it visible? I think I need to change the viewer mode.
It's visible.
Okay. So, as I mentioned, the comparative analysis, I'm looking at 5 countries: the United Kingdom, Israel, Australia, India, and South Africa. So I'm going to look at 10 areas. The 10 areas that I'm going to look at, the first one is the legislation that is in these countries. The second one is the genetic link, which is an ethical issue, commercialization, which is an ethical issue, same-sex or singles living, which is an ethical issue, place of domicile, surrogacy agreements, profile of the surrogate, maternity leave rights, this case law from South Africa, when you look at maternity leave rights, the place of legal motherhood, which is the most crucial one, because none of these countries have legislation on surrogacy. Then lastly, gaining of custody or transfer of parental rights. So I'm gonna start. So I'm gonna start with, are you able to see this, my screen?
Yes, people can see it.
Okay,
Yes.
good. Okay, so when it comes to the legislation, the UK has 2 separate acts of parliament. They have one that talks on the fertilization, and they have one that talks on the surrogacy arrangement. So the one that talks on the fertilization, it's known as the Human Fertilization and Embryology Act, which was passed in 1990. Then they had a major amendment in 2008. Then separately, they have a Surrogacy Arrangement Act. So you see, they have 2 different types of legislations. They've not merged the 2 processes into one. Then in Israel, they have what they know as the Israeli Embryo and Carrying Agreements Act. And if you get a copy of that act and you read it extensively, you'll find that surrogacy or ART in Israel is really, really state controlled, because the state forms a committee, and any agreement where people want to have a child through ART and surrogacy has to be approved by the state. So it's really state controlled. And I think also this stems from their religious background, where they believe that the Jews should probably not mix with others of different faith or something like that. Then we have Australia. Australia, you realize that Australia is divided into states, and when it comes to regulations governing surrogacy arrangements, they are administered at state level. Then we have India. For a very long time, India was known as the baby factory for IVF and surrogacy, and India really boomed because, one, the costs were very low. Then they had so many specialists, and also because of population, an intended parent who wished to have a child found it easier to go to India and get a surrogate, and because of the low cost, that they would also have the IVF there. So for a long time, it boomed, and because it was unregulated, a lot of unethical issues crept up, where now it became like a baby factory, where it's not regulated. Some women were now just churning out babies because they want money. And the agents, because when it's not regulated, then you also get agents coming in. So some of the agents also did not care much about the health of the women. They cared about the money. So there was a ban in India, and there was a ban in India, but before the ban, they had regulations under the doctors, but there was nothing legal. However, after after the ban, finally in December, I think it was between 20th and 24th of December 2021, they passed 2 legislations. So they have the Surrogacy Regulation Act, then they have the Assisted Reproductive Technology Act. So you see, India also, like the UK, they have 2 separate legislations. One talks on the surrogacy, one talks on assisted reproductive technology. Then we have South Africa. South Africa, the ART also is in a different legislation, but their Children Act has provisions for surrogacy. So anything to do with surrogacy in South Africa, it's under their Children Act. Then we come to genetic link, which is an ethical issue. In the UK, where the intended parents are married, then at least one of them must have a genetic link to the child. But where it is a single parent wishing to have a child through surrogacy, then that parent must be the one supplying their egg or sperm. And the same happens in Israel, the same happens in Australia, the same happens in India, and the same happens in South Africa. So all these countries insist, as per legislation, that one of the intended parents, if not all, must at least have a genetic link to the child, because the argument is this: if none of you has a genetic link to the child, but you want a third party to carry this child for you, and South Africa has a very good case law on that, then why don't you just go for adoption? Because, I mean, you are not carrying this child. The intended mother is not going to carry this child. She's getting a surrogate. But then the embryo has not come from either of you as a couple, or if you're single, the egg has not come from you. So what's the difference with not just going through adoption? So because of that, all these countries have legislated that you must have a genetic link to that child. Then the third one is now, is it commercialization or altruistic? In UK, it has to be altruistic. And I'm very careful when a couple approaches me and they're from the UK, if I'm handling them from the word go and they ask me to do an agreement where they will be providing monetary compensation to the surrogate, the way I word that agreement, I word it in a way that anyone looking at it at the British Embassy months later, when the baby has been born and the parents are applying for exit, they will see the agreement, yes, they will see the consideration that the IPs had agreed to give the surrogate, yes, but the way I will word it, it will be as a compensation to the inconvenience, because when you are pregnant, your body does not differentiate that the pregnancy you are carrying is yours or for someone else. As a woman, when you're pregnant, you will go through all the emotions. So how you word it makes a difference, because in the UK, they are very strict. It has to be altruistic. In Israel, they are encouraged, whether you want to do commercialization or altruistic, no big deal to them. In Australia, strictly altruistic. In India, very interesting. If you're an Indian citizen, and India doesn't have dual citizenship. So if you're an Indian citizen, they allow you to do either altruistic or commercial, your choice. And it depends on your agreement with the surrogate. However, if you are a foreigner, then you can only do altruistic. The commercial one was banned in 2015 for what I've explained earlier. Same with South Africa, it has to be altruistic. And by altruistic does not mean that the surrogates don't get compensated. They do get compensated, but you just have to be careful when you're doing the agreement on how you word it. Because especially if they're foreigners and they've come to your country, remember they'll be going to the embassy to get exit for the child and for themselves with the child. And the country, the UK is very strict. Whatever was done in Kenya, does it meet the legal standards in the UK or whichever country that they're going to? Mostly UK and Australia, you'll find that they have almost the same set of laws. Then the fourth analysis we are looking at is same-sex, couples, singles, or live-in. Now, again, we are looking at the first country being the UK. The UK, interestingly, did not allow for single women or single men to have a child through surrogacy, but for a single parent, but they allowed for the gay. Now, if you're from Africa, where we still have a lot of religious, cultural, and legal resistance on same-sex relationship, you'll find that it's quite ironical that they found it okay and legal for people in same-sex relationships to have child through surrogacy, but not for a single parent. However, they passed the remedial order, which is like an amendment to the Human Fertilization and Embryology Act in January 2018, and that it has now, January 2019, and it has now allowed for single parents to get a child or children through surrogacy. In Israel, from February 2020, they allow for same-sex couples to have a child. In Australia, again, they allow, but now this depends on the state. You should be residing either in Queensland, Tasmania, or New South Wales. So if you are residing in a state that does not allow for same-sex partners to have a child, then all that you do is you either move or you get a surrogate residing in a state where same-sex people are allowed to have children through surrogacy. So you get your surrogate living there, and even where the agreement is signed or where the fertilization takes place. In India, it's prohibited. In South Africa, singles, people in same-sex unions living, it's allowed. Now, place of domicile. In the UK, at least one of the parents or both of them must be domiciled in the UK or any of the Channel Islands that form part of the British Isles. So if you are having a child in Kenya through surrogacy and you're British, at least if you're not both of you living there, at least one of you should live there. And this is also for issues of getting the child either residence permit or citizenship once the child has been born, for you to be able to claim citizenship so that you can get exit travel documents to leave the country with the child. In Israel, the law requires that the IPs must be habitual residents in Israel. Australia, it's not a requirement that you must live in Australia. And in India, commissioning parents must be residents in India. And the reason, after they passed the legislations in December of 2021, and now they opened up, they now allow also foreigners to be surrogates in India. Now, in South Africa, they allow both people who are either citizens of South Africa or not. However, should there be a dispute, then you can only benefit from legal protection if you are resident in South Africa. Now, what about surrogacy agreements? In the UK, you may not enter into a surrogacy agreement, but it's not enforceable. The Section 1A of the Surrogacy Arrangements Act provides it's not enforceable. Now, in Israel, it's enforceable, but it has to be approved by the state-appointed committee, which is 7. In Australia, like the UK, it's not enforceable. So if the surrogate decides that she's not handing over the baby, there's nothing you can do, even though the surrogate knows that they don't have a genetic link to the child. And the kind of surrogates we are talking about, remember when Ruby was handling her session, she mentioned both traditional and non-traditional. Sorry, she mentioned traditional and gestational. So the surrogates we are talking about here are gestational surrogates who have zero genetic link with the child. That irrespective, the surrogacy agreements are not enforceable. Same with India. Now, South Africa, what happens in South Africa is, if you don't validate the agreement and there's a dispute, then the agreement will not be enforceable. In South Africa, once intended parents decide that they're going to have a child through surrogacy and the doctor has cleared them, they've gotten a surrogate, then they have to take the agreement to the court and have the court validate that agreement. There'll be a hearing. And recently, I think it was either this year or last year, when one of the High Court judges in South Africa said that if a surrogate now is going to carry a child for IPs and the surrogate has older children, those children must be assessed and a psychological report written on them, because they will see their mother pregnant and they will be expecting a sibling, but their mother pops the child and the child goes. So recently, less than a year ago, the South African High Court passed a judgment that for a surrogate to carry a child, one of the requirements is that her children must be assessed. So profile of the surrogate, I'm not going to go through this because I'm looking at time, and the previous speaker had already covered it under her session. But each country has profile of the surrogate. Minimum, they have to be adults. Except that in the UK, the interesting bit is that you can be single, you don't have a biological child, but the law allows you in the UK to carry a child for someone else. In most of the countries, you must have had at least one viable pregnancy and a live birth. But in the UK, you're single, you're in your 30s, you have no maternal instincts, you don't have an interest of being a mother, but you can carry for someone else. Now, maternity leave rights. There's case law on this in South Africa, where a gay man and his partner, they had a child. So when he went to ask for leave, he was refused and told, wait a minute, we did not see you pregnant. And as per the company policy, maternity leave rights can only be awarded to persons or to women who've gone through pregnancy. He went to the employment court and there's a judgment. I'm going to share this either in the chats or with the ELS secretariat, and they'll share with you the citation of the case. And there was a judgment from the employment court that since South Africa recognizes gays, since South Africa recognizes their right to have a child through surrogacy, it also means that they have a right to go for maternity leave rights. And it's not, the right is not just pegged on them, but it's also in the best interest of the child they've had that their parent should be awarded leave rights so that they have an opportunity to bond. So the first country we are looking at is UK. Surrogate mothers are entitled to paid leave. The intended parents, we will also have the responsibility to take care of the child, are also entitled to leave. In Israel as well, they have paid leave. In Australia, all of these countries have a right. The interesting bit again in Australia is, as an IP, I've had a child through surrogacy, but if I do not want to take my leave and I have someone within my household who is still under employment but has agreed to take leave, maybe my mother is living with me, she's in her 50s or early 60s, she's not reached retirement age, then she can approach her employer and apply for paternity leave so that she gets time to look after this child that is mine through a gestational surrogate. Very interesting. Remember in Kenya, if you've been following, sometime when our former president was still in power, there'd been a provision in the Employment Act when it was going through an amendment that that leave rights be granted to parents who had a child through surrogacy, and which I agreed with the president because he refused that provision because we do not have yet legislation on surrogacy. But here we were proposing in an amendment that they should have a right to, maternity leave. Though if you have a child through adoption, then you have a right to maternity leave. Then what happens to legal motherhood? In all these countries, the UK, Australia, Israel, South Africa, and India, the legal motherhood rests with the surrogate. Unfortunately, in India, when you look at the legislation that they passed in December 2021, it's still not very clear. But in all countries, and even if you look at the US, the different states in the US where they have regulated for surrogacy, the legal motherhood rests with the surrogate. And the reason why this is done, because you must also be alive to the fact that we have the issue of human trafficking. If you leave it open where you don't regulate, where a surrogate pops a baby, and there's no legal process for the transfer of this baby from the surrogate to the commissioning parent or the intended parent, then you leave a loophole for child trafficking. If you are Kenyan, you'll be alive to the fact that some years back, about 20 years back, we had a very big scandal at Pumwani Maternity Hospital, which is one of the largest maternity hospitals in East Africa, where this preacher had women who got children, and he made them believe like that you had children, not twins, not triplets, but that you had single births within a year. How? Because in a normal gestational period, you carry a child, if you carry a child to full time, it's what? 40 weeks, 10 months. But here's a woman claiming, and she believes she had the child. That was clearly human trafficking, and it led to Kenya developing what we now have as the Counter Trafficking in Persons Act. So to protect children.
Wrap up.
All right, I'm going to my last one. So to protect children, the surrogate motherhood has to remain with the mother. So even in your respective countries, when you are working on these bills, or the one for East African community, the surrogate motherhood has to remain with the surrogate mother. There has to be a legal process because you have to protect the child. Then the last one is gaining of custody. And this is where now there's a lot of issues. You've come from the UK, you've come from US, you've had a child in Kenya, or whichever country, or Rwanda or Uganda, the child has been born. How do you pass on the parental rights for the IPs to exit the country with a child? So what happens in the UK is they have two ways. You can either go for parental orders or you can go for adoption. In the UK, they give a window period. You go to the court when the child is between 6 weeks to 6 months. So even though the IPs take custody, actual custody immediately after birth, they cannot go to the court until after 6 weeks to apply for parental orders. So after 6 weeks, and when the child is below 6 months, you go to the court, and this is the magistrate's court in the Crown Court in the UK. You go to the lower court and you get transfer of parental order. In the UK, they call it parental order. In Kenya, we don't have parental orders in our Children Act. But if you wait until the child is after 6 months, then in the UK, now you have to go for adoption. And that is also the same in Australia. In Israel, it's a bit different. You begin the process within 7 days after birth. And once the father, you go to court, you begin the process 7 days after birth. And remember that the selection committee had, before you started the process, made an approval. So the transfer is very easy. In Australia, as I've said, it's the same process as in the UK. You have the window period between 6 weeks to 6 months. After that, then you have to go to the High Court. In Australia, they call it the Federal Magistrates Court for now parental rights or adoption. In India, again, you go to the lower court for an order. In South Africa, because in South Africa, the interesting bit is before the transfer was done, you had gone to court and had the agreement registered. So when the baby is born and the IPs have taken actual custody, after the window period within which the surrogate is allowed to either change her mind or not, after that window period elapses, the commissioning parents or the intended parents, all they need to do is go back to the High Court in South Africa and have those orders confirmed and transfer done to them. What happens in Kenya is, as per the Section 10 of our Births and Deaths Registration Act, legal motherhood remains with the surrogate. So the birth notification, and rightly so, is in the name of the surrogate. The problem now is, how do you transfer to get it to the parents? When I handle these cases, first of all, I will look at where do the IPs come from? Are they Kenyans or they are not Kenyans? If they are Kenyans and they want a birth certificate, I will tell them, let's go for adoption, because you don't I mean, you will not be pressed for time that, oh, adoption will drag in court and I have to rush back to work. I'm from US and all that. But if you're from the US or you're from Australia and all that, because previously we would go to the children court and they'd give us orders for birth certificate. But then the registrar for births insisted that we must make them an interested party. So when you make them an interested party and you serve them, they bring in the government legal representative, which is the AG. The AG automatically raises a PO. Even though I have done a case that successfully dismissed the PO that the AG raised, they still went to High Court. It was we won. Their PO was dismissed. But you see, if you are IPs, your clients, the IPs, they don't have the luxury of time. They cannot wait with you 1 year. You'll get fired in between, like I was. The case was still proceeding, but in between I'd been fired. But they had not filed. So you have to get to know which country your clients come from. Do they have the luxury of time, and which is the best forum? If they are from US, we will simply go to the children court and get custody orders for them to leave. And then the surrogate will relinquish her rights, do a notarized affidavit. Then they can sort themselves out once they leave Kenya and they go to US for adoption, because the US, so long as they have the custody orders, the US Embassy in Nairobi will be able to give them exit and travel documents. Thank you so much. Pressed for time, but that's all I had to share today. Thank you.
Thank you very much, Enrica. That was very insightful. And from the presentation, we can see that to get the legal aspects of ART, specifically surrogacy, we had to go beyond the East African borders to across the border to see how the other countries have managed to find some sort of middle ground. Because you see, Ruby raised all the ethical issues that are still that we are still grappling with. So we have seen how other jurisdictions have tried to tackle some of these issues, but of course some are still gray areas. Now, given the way time has really gone, members, we might not have time for plenary, but I can see our panelists have tried to answer all the questions on the Q&A session. Sorry, at the Q&A section. I can see there are very many requests for the slides and for the presentation. Just know, members, that this entire session was being recorded and it will be shared on all social media handles for the East African Law Society. So if you want to catch up with the presentation, or if there's one or two bits that you missed, then you can follow us on, you can go to the ELS socials on Facebook, Twitter, YouTube, and LinkedIn. All of them are at EA Law Society, EA Law Society. If you just type that, you're going to get the presentations. Now, due to the constraints of time, we'll just get our speakers to give us their final thoughts. Then we shall wrap up this session, but they will be available on the socials to answer all and any questions that we may have. So let us get your closing remarks. Chris, we start with you, closing remarks. And sorry, before you give your closing remarks, yes, the list of cases that have been referred to will also be shared, but now on our socials. And if you look at the chat section, Enrica has shared case law for one of the cases that she referred to, but all the information will be shared to the members, especially regarding the cases. Chris, let's get your closing remarks, Chris.
Thank you so much. I wouldn't really take much time to say a lot. I would just highlight that as we have seen in the discussion, assisted reproductive technology is something that is not really well known by many people, not only those who attended this webinar, but across the East Africa and even beyond. Which is why I would just recommend that the discussion should continue, and we should aim at least having a policy and legal framework in our domestic countries, so that women or persons who wish to go through this procedure and processes don't really go to India or South Africa or UK, at least where the regulation is advanced. That's all I would say. And thank you so much for the opportunity and the learning platform.
Thank you so much, Chris. Ruby, your final remarks?
Mine from a practitioner's perspective, can we kindly lobby for laws to be passed as soon as possible? Because now we're just operating blindly, and a lot of things are going on that may interfere with the practice later in the years to come because of what is happening. So I would like everyone who is involved to lobby for laws. In the meantime, especially lawyers, can we use our legal knowledge and other aspects to really streamline ourselves within the practice, whatever laws that are already in place, to streamline ourselves into that? And medics, can we do an ethical kind of thing so that at the end of the day, it's for the benefit of the patient? And most importantly, let's not forget that the byproduct of all assisted reproductive technology is a child who never wanted to be here in the first place, may or may not have wanted to be here in the first place. So in whatever we do, let us bear in mind the best interest of the child. That's it.
Thank you very much, Ruby. Enrica, final thoughts?
Thank you, Angie. Thank you, my co-panelists, and everyone who is in attendance. As a family law practitioner, and echoing what Ruby has said, any product of an IVF is a child. But when you read even the draft, the draft bill with the East African community, or even the RT bill in Kenya, the voice of the child is missing. So as a practitioner or as an advocate, when you look at those bills, if you decide to do advocacy or lobby, make it central that the voice of the child needs to be heard. And the voice of the child has to be heard through whatever is in their best interest. And also, we need to be selfish as advocates. If we don't guard also on the issue of the transfer of the surrogate, the child from the surrogate to the IPs, apart from making children vulnerable to human trafficking, we are also going to lose business. This is our bread and butter. So you have to guard it fiercely where you lobby, whether at the regional level or in your domestic spheres. You must lobby that there has to be a court process. But as you lobby that there has to be a court process, you look at what is provided for internationally. There's no country of all that I've shared that allows children to simply be passed from a surrogate to IP. So, I mean, let's continue with the ball rolling. Kenya now has two draft bills. I mean, let's work with the committees. Let's make our voices heard. And thank you so much.
Thank you so much to our panelists. Again, members, this has been a very, very insightful topic, and it is a very broad topic. I think each speaker could have been given 1 hour or 2 hours to speak, and maybe they could still have gotten content. So let me apologize to our members, maybe who had their hands up, or if they did not get a chance to have their questions answered on air, or if they did not get a chance to air out their views. It is just because of time. But the upshot of the presentations is that there is need for a legal framework to govern there's need for a legal framework to govern this whole process. And I like what Enrica has said. Even as we are lobbying in our own personal spheres of influence or on a regional platform, we need to make sure that the voice of the child is heard, because there are so many ethical issues that Ruby has raised. Supposing a surrogate, a child has been brought forth, then the intended parent decides that they don't want the child anymore, what happens? So we really need to have a robust legal framework that will handle some of these issues. So it is up to us as legal practitioners or as citizens of East Africa and as citizens of the world to make sure that we guard jealously the generation that is coming. For your information, there is that bill that is pending at the East Africa Legislative Assembly. In Kenya, there are 2 pending bills. In Uganda, there's a pending bill on the subject, though they are all titled differently. Let us do our bit in lobbying for these bills to be passed into law.
And in Rwanda, there is an ongoing bill.
Sorry?
Rwanda, there is an ongoing bill on.
Yes.
Yeah.
Thank you for that. Even in Rwanda, you see, there are so many things in the pipeline. So we need to use our own individual influences. Even keeping the conversation going will also help in making sure that at least some of these things are brought into the forefront. Even if it is just guidelines or proposals or best practices, because as Ruby says, right now we are grappling in the dark. So I want to thank all of you very profusely for your attendance, for your attention throughout the whole presentation. Again, the webinar will be shared on all socials for the East Africa Law Society at EA Law Society, where we'll keep the conversation going, and we shall try our best in our own small way, because you see, together we can move very far, especially in this ART sphere. So with that, enjoy the rest of your afternoon and your evening. Happy Valentine's Day from myself and from the East Africa Law Society Women Lawyers Committee and the larger East Africa Law Society. Thank you very much, members. And once again, happy Valentine's Day. Bye. You can leave at your own pleasure and leisure.